Welcome to U.S. Immigration. Good news. Department of State is waiving in-person interview through a temporary final rule effective immediately from December 13, 2021 for certain immigrant visa applicants to reduce the massive visa backlog in embassies and consulates abroad. We also have other major policy changes from DHS, USCIS, and DOS discussed in this video. Department of Homeland Security is requesting public input on minimizing the separation of migrant families. The U.S. Citizenship and Immigration Services canceled policy requiring interviews of all petitioners filing Form I-730, so no interview is needed for these applicants. Department of Homeland Security suspends employment authorization requirements for some F1 students. The U.S. Citizenship and Immigration Services temporarily waive civil surgeon signature requirement on Form I-693. The U.S. Citizenship and Immigration Services expands premium processing for certain dependent family members, initial visas and visa extension, E.A.D and certain GreenCard applications. Some of these rule is classified as a final rule, which means a full notice and comment period is not expected. Once OMB, Office of Management and Budget clears the rule, it will be published in the Federal Register and become effective according to the terms of the rule. If you are interested in these topics, please stick around till the end of this video. For your immigration news and updates, please like this video and subscribe to the channel. Do not forget to hit that notification bell. Let's get into the video. Department of State is waiving in-person interview through a temporary final rule for certain family immigrant visa application. Similar flexibility to waive in-person interview was provided in the past, only to employment-based non-immigrant visa applicants through Dropbox. Now it is extended to family-based immigrant visa applicants. This temporary final rule, TFR, provides flexibility for consular officers to waive the personal appearance of certain repeat immigrant visa applicants who were approved for an immigrant visa in the same classification and on the same basis as the current application on or after August 4, 2019. It also gives consular officers discretion to allow the subset of immigrant visa applicants to affirm the accuracy of the contents of their application without appearing in person before a consular officer. This temporary final rule is effective immediately and expires after 24 months. In simple terms, if the immigrant visa applicant who is applying for the same type of visa, which was previously approved on or after August 4, 2019, need to sign the declaration stating the information is true in DS-260 or DS-360. The U.S. Department of State will temporarily waive the interview requirement for those immigrant visa applicants, according to a temporary final rule published Friday. The rule will be in effect from December 13, 2021 to December 13, 2023. According to this rule, the consular officer can decide to waive the in-person interview for these immigrant family applicants and can contact them via telephone or email for additional info. The rule is designed to help address the problem of applicants who are unable to travel due to the COVID-19 pandemic and who must meet specific time-limited criteria, said the State Department. As per INA, Immigration and Nationality Act, in-person interview usually allows consular officers to make sure the visa application is credible while also allowing applicants to correct any mistakes on their application. However, in-person interview may not be required for all, as per latest rule. Since requiring a repeat family immigrant visa applicant to be interviewed again would significantly increase the backlog and take away the consular resources who could have served to interview other applicants. Let's get into the next topic. Department of Homeland Security request for public input on minimizing the separation of migrant families. Department of Homeland Security recently published a request for public input on recommendations for ways to minimize the separation of migrant parents and legal guardians and children entering the United States, consistent with the law. This input will be used in the drafting of a report required by the executive order titled Establishment of Interagency Task Force on the Reunification of Families. These reports are provided to President to improve the rules and process in favor of migrant families to avoid these separations in future. If you or your attorney willing to provide inputs, you can do so by following the link in description. Comments are due for this by January 10, 2022. Let's get into the next topic. The U.S. Citizenship and Immigration Services canceled policy requiring interviews of all petitioners filing Form I-730, so no interview is needed for these applicants. The policy memorandum, which directed the phased expansion of in-person interviews for Form I-730 petitioners, imposed significant burdens on refugee and asylum seeker populations. This is inconsistent with Executive Orders 14,012, restoring faith in our legal immigration systems and strengthening integration and inclusion efforts for new Americans, and also inconsistent with Executive Orders 14,013, rebuilding and enhancing programs to resettle refugees and planning for the impact of climate change on migration. The rescinded policy also decreased approving efficiency of USCIS by requiring petitioner interviews, in addition to the routine beneficiary interviews in cases without any identified deficiencies in the petitioner supporting documentation. USCIS can perform robust fraud and security screenings and maintain strong program integrity without this blanket interview policy. In addition, USCIS reserves its authority to interview any petitioner where USCIS determines there is a need to do so. Let's get into the next topic. Department of Homeland Security suspends employment authorization requirements for some F1 students. The Department of Homeland Security has temporarily eased certain regulatory requirements for some F1 students. Hong Kong residents who are F1 non-immigrant students and are experiencing severe economic hardship as a direct result of their emergent circumstances. As a result of this, they can now request employment authorization from November 26, 2021 through February 5, 2023. They can also work an increased number of hours while school is in session. They can also reduce their course load while continuing to maintain their F1 student status. To be eligible, individuals must have been lawfully present in the United States in an F1 non-immigrant status on November 26, 2021. DHS will consider F1 non-immigrant students who gain employment authorization engaged in a full course of study for the duration of their employment authorization if an undergraduate student is registered for a minimum of 6 semester or quarter hours per academic term, provided a graduate-level student is registered for a minimum of 3 semester. USCIS to temporarily waive a green card rule. USCIS said will temporarily waive the green card requirement for a civil surgeon's signature in Form I-693. Now the report of medical examination and vaccination record will not require signature 60 days before an applicant files an application for an underlying immigration benefit. This rule is valid until September 2022, and it also applies to Form I-485. The goal of the rule is aimed to reduce backlogs and helping applicants affected by the COVID-19 pandemic and related processing delays. Expansion of premium processing for more visa types and immigration benefits. The U.S. Citizenship and Immigration Services final rule that would expand premium processing to include additional case types has been submitted. This rule will speed up certain GreenCard applications, employment authorization I-765 E.A.D applications, and certain dependent family members, new visa and visa extension applications for a $2,500 premium processing fee. The rule is classified as a final rule, which means a full notice and comment period is not expected. Once OMB, Office of Management and Budget clears the rule, it will be published in the Federal Register and become effective according to the terms of the rule. The new legislation will now allow premium processing service for following immigration benefits. Applications to change or extend non-immigrant status. Applications for employment authorization. Employment-based non-immigrant petitions and associated applications for dependents of the beneficiaries of such petitions. Employment-based immigrant petitions for EB1, EB2 and EB3. Any other immigration benefit type that the Secretary deems appropriate for premium processing. The specific contents of the final rule, including the case types eligible for premium processing, processing timelines, and corresponding fees and implementation dates will be posted for public inspection at least a day before officially publishing the rule in the Federal Register.